Good morning, Your Honors. Attorney David Harvey on behalf of the City of Lorain. May it please the Court, I'd like to reserve 5 minutes for rebuttal.
Yes.
Thank you. We are here today on the City of Lorain's appeal of the trial court's granting of the motion to vacate of an arbitration award of arbitrator Greg Zutter. The City has brought up two basic assignments of error. The first one involving whether or not the arbitrator exceeded his powers when he engaged in a probable cause analysis which was related to the constructive discharge issue, which was clearly before the arbitrator. The second assignment of error deals with the trial court's decision to substitute its own legal and factual conclusions into the record, into its decision, which I will discuss further. To begin, I would urge the Court that this is a de novo review. I know that the appellee has argued a bit and said that this should be looked at as a matter of law. I don't disagree. I believe that this Court has to review the trial court's decision to see if they did in fact adhere to the law, which is enunciated in 14CA010717. If in fact the trial court exceeded their powers, then as a matter of law, this Court should overturn the motion to vacate and confirm the arbitration decision. However, though, we would argue that it is nowhere near an abuse of discretion issue, that the Court is to look at this de novo and take a fresh look at this by giving no deference to the trial court. As it relates to the first assignment of error, it is noted in our brief, and I will go over it today, that the constructive discharge was an issue of paramount importance to this grievance. Constructive discharge was mentioned multiple times in Mr. Cologne's grievance, his initial grievance. It was mentioned multiple times in Mr. Stumphauser's communications with the City before the grievance was accepted. And in fact, constructive discharge was spoke about with arbitrator Zutter and mentioned in the stipulations on page 12 of the decision that this in fact was the most, an issue of utmost importance to this matter. There was the issue of arbitrability as well, which was basically a statute of limitations argument. That is not being argued today by either side. So in sum and substance, it's almost disingenuous for the appellee in this instance to say that constructive discharge and the related legal analysis that goes with it was somehow beyond the powers of the arbitrator.
Well, what were the precise questions submitted for arbitration?
Sure, and I know there is a bit of confusion on that, and I will admit that I was a little bit confused myself. However, if you look at page 12 of the actual arbitration decision and award, you'll see that in the middle, the arbitrator references a letter of November 14, 2012, which was appendix to this, to our brief as Appendix C, states that the arbitrator's letter of that date summarized two issues. One, arbitrability, which we're not dealing with today. Two, constructive discharge. That is written in page 12, right in the middle of the arbitrator's decision. Furthermore, on page 6 of the transcripts, if this arbitration was transcribed fully, page 6, the arbitrator mentions right in the middle of the page that the issues before this court, or before the arbitrator, have been decided, well, quote, there are two issues, on the merits and one on arbitrability, and they are essentially stated in my letter to counsel of November 14th, so we will move on that basis. Therefore, if you reference both page 12, which references the November 14th letter, and if you actually look at the November 14th letter, you will very much see that constructive discharge was the only issue outside of arbitrability placed before the arbitrator. That makes sense because Mr. Cologne, as we allege, quit his job. If he quit his job and it was a voluntary quit, end of story. Then he has no rights under the CBA. He can't grieve a discharge. However, if he was found to be constructively discharged, then he would be allowed back into the door of union protection and permitted to grieve whether or not there was just cause to terminate outside of the resignation. So it would make sense that the only way Mr. Cologne gets back into the door is that constructive discharge has to be proved. As the arbitrator wisely pointed out, the city had the burden to show that he wasn't constructively discharged, that it was a voluntary, non-coerced quit. And that's where the probable cause determination comes in on this. The arbitrator, and I don't think the parties will dispute, that Kinney versus the Ohio State Board of Services is controlling in this matter and lays out and stands for the proposition that, in sum and substance, if there is a resignation in lieu of a termination based on founded or meritorious charges, then the resignation is not coerced, it's voluntary, it's a good resignation. In this case, and this is where the appellee tries a little sleight of hand, in this case they went through, the arbitrator said, okay, let's first look to see if there was actually just cause for the termination. Because backing up, the arbitrator says, in order for that, there must be a quid pro quo. There must be a bargain for exchange. The city must be giving up something, the employee must be getting something in return. And so the arbitrator does the first analysis. Was there just cause for the termination? Because as the city argued in the alternative, okay, let's say that the quit was bad and that you got to bring him back. We have reason to fire him anyway, so he's still out the door. So while he may come back into the door for a brief period, we're kicking him back out because we have reason to. The arbitrator found that we didn't have that. That was an argument in the alternative that we made. The arbitrator said you did not have independent grounds for the city to terminate Cologne's employment. However, if you look at the page 13, and this is what the appellee clings onto, the second issue states, and this is where you have to really read carefully, was there just cause for the termination of the employment of the grievant? You have to look at that. It's not was there just cause for the city to terminate Cologne's employment, as was there just cause for the termination of the employment. In this case, Mr. Cologne was the one who terminated his employment by voluntarily resigning. So,
well, how can you have just cause for a resignation?
It's a fairness, you know, and in that it's a term of art that is used in arbitrations that just cause can be looked at. There's a Doherty test that has 8 steps that you look at. Just cause can just be said, is it fair? You know, is it equitable? I think the arbitrator may have used a word that caused some confusion, and I think that's where the appellee really grasped onto this. But it looks at, was there fairness for the termination of the employment? It doesn't say whether or not the city had grounds to terminate. The question, and it goes part and parcel with the page before, it only makes sense that if we're to decide constructive discharge, we must decide whether or not what he's calling constructive discharge can also be called termination. So basically, is the set of facts that led to Mr. Cologne leaving the employ of the city of Lorain, is it fair? Is it kosher? And that's what that second issue for decision stands for. And it only makes sense because the issue of constructive discharge was talked about extensively as the 2 issues that were before this court. Moving on to that, the court, or the arbitrator, did state that we did not have just cause to terminate him. However, he then moves on to the second phase of the analysis, which is necessary in Kinney. The appellee would have you end it there and say, oh, there was no just cause. Well, that's not the case. The arbitrator moves on to the next phase of the analysis, where he states that, okay, we need to see if there is some sort of bargain for exchange. Let's see if the charges of theft in office were founded and meritorious. And that's where the probable cause determination comes in, where he determines whether or not under Kinney, whether or not the theft in office charge was founded and meritorious. Conversely, you have to think about it like this. If Mr. Fowler at the time had accused Mr. Cologne of stealing a car, and there was absolutely no basis for it, but he made it sound like, I don't care if he stole it or not, I'm the safety service director, I'm going to push through this charge, you know, and whether it's right or wrong, you know, you're going to have to resign if you don't want to deal with this bogus charge. And that's what Kinney says you can't do. You can't bring up bogus charges because you're in the position of power and threaten the employee with that as a means to make them resign. If the charges are founded, then that is allowable under Kinney. And in this case, he determined by probable cause standards that the theft in office was more probable than not had occurred. And in fact, you didn't need Mr. Cologne's testimony to flesh this out. He double-dipped. Whether or not he did it intentionally, that's a jury issue. However, if you look at the plain facts of the case and you look at what theft in office requires, it requires a theft to occur, and it requires it to be done under the auspices of in the official capacity or involve city funds. And in this case, they both did.
And you are at your 5 minutes. You may continue if you wish to. I just wanted you to know.
I will just briefly state, as it relates to the second assignment of error, the opinion is founded upon the factual and legal conclusion improperly made by the trial court that there was no theft in office. That is the foundation for the trial court's decision that, and I will bring up probably in my rebuttal, but basically he says that there is no quid pro quo when there are unfounded charges. And that is a strictly legal and factual determination. The arbitrator determined that there was probable cause for it. The trial court didn't like that determination and improperly, severely and improperly imparted its own judgment as to what it thought, as its opinion as to the theft in office, which was outside the purview of the powers of the trial court. Thank you.
May it please the court, my name is Leslie Wolf, and I recently made an appearance for purposes of oral argument on behalf of the appellee, which is the Union of the International Association of Firefighters, local number 267 for the city of Lorain. I will note before I begin that the employee that's the subject of this case, Mr. Joseph Colon, is here and is actually the real party in interest, and therefore at times I might refer to Mr. Colon as the appellee because in a sense he truly is the party that is disputing the arbitrator's award. First, I would just like to reassure your honors that if you're having trouble understanding the city's position, you are not alone. We are also having trouble understanding it. And I commend opposing counsel for making a valiant effort to explain what the city's position is. I am still struggling to understand what he is saying. And that's because it's irrational. It doesn't make sense. And therefore, I'm not going to try to understand it, but I'm going to explain what really happened here and what this court needs to decide. Mr. Colon was terminated from his position as a firefighter with the city after 16 years because the arbitrator found, quote, cause to believe theft in office probably occurred. Probably occurred. He didn't find that theft in office did occur. He didn't find probable cause to charge Mr. Colon with theft in office.
Excuse me, but didn't he say abuse of sick leave constitutes theft in office when the employee is working out while out sick? In order to constitute conviction of resignation, the threat of prosecution says this fact would support a prosecution for working on sick leave at the Cleveland Clinic on December 23, 2010. Isn't that what he was saying, the arbitrator, at that time?
He found one incident of potential abuse of sick leave, which was in 2012. The incidents in 2010 were completely time-barred and could not be the basis for misconduct. But the arbitrator ignored that and went back and tried to use them as a basis for misconduct, but he found no misconduct. To find probable cause is not finding misconduct, and the just cause standard requires, under the law, and I don't think that anyone can dispute this, that there's a two-pronged test. First, the court has to determine that the misconduct for which the employee was disciplined happened, that the city established that it happened. And next, on the second prong, whether the discipline that was imposed was at the appropriate level for that misconduct. To find that someone might have committed theft in office, or that it probably occurred, is not finding that anything actually did occur. It's actually a far less standard than is required for just cause. So I think the court should understand it in that way. So there was no just cause finding. And just cause is the only standard under the collective bargaining agreement that is sufficient to justify progressive discipline. And in fact, there was no progressive discipline here. There was only immediate discharge. There was never any suspension or even consideration of a lesser penalty.
There would be a grievance process when he resigned.
He resigned in the face of a threat of being discharged. An inappropriate threat that violated the CBA because it didn't follow progressive discipline.
Well, you know, reading the briefs, it's like there are these alternative realities. On the one hand, I understood your brief to argue that your client was pressured and didn't have time to really think about things and just, you know, made a very quick decision. On the other hand, there are references to his having more time left to make the decision after having, I guess, perhaps talked with his wife or family or something, then came up with some recollection of facts that he had not thought of before, but it sounded like it was much more deliberative than just a snap decision.
And I would propose that it doesn't matter, Your Honor, because you're now within the world, this fabricated universe of a contract theory, of bargaining for consideration, which we propose goes beyond the collective bargaining agreement. That was not the standard for imposing discipline. The whole theory of whether it was voluntary because it was induced by founded charges of misconduct is not the standard for just cause. So I think that's sort of a red herring, and I don't think it really matters whether he decided it at the May 8th hearing or 3 days later or 6 days later. Now,
And you have about 30 seconds.
okay, how did that happen? Oh my goodness. Don't I have 15 minutes?
Oh, I'm sorry, you're right.
I know it goes fast, but
Yes,
not that fast. My goodness.
I'm looking at the wrong time.
Okay, so, Your Honors, we suggest that the arbitrator fabricated a new standard, having not found just cause based on the test for just cause, i.e. misconduct and appropriate discipline. The arbitrator strayed and went beyond and decided, well, I'm going to come up with a new standard for when a public employee can be disciplined under this agreement. And that's why the trial court had to vacate, and I believe that's why this court must find that the trial court did the right thing and affirm. There's another case, the International Association of Firefighters case, which was briefed, or was mentioned in the briefs. That's a very similar case, where an arbitrator was trying to define what a disability was and whether firefighters' claims of carpal tunnel syndrome were within the definition of disability. The arbitrator looked to other agreements to define disability and used a definition that added an additional element that shouldn't have been added. And in that case, the Supreme Court reversed on the lower courts and found that the decision should have been vacated from the start because the parties did not bargain for that standard. Here, it is the exact same thing. The parties did not bargain for a standard that says if you probably committed an offense, that's just cause to discharge. And in fact, even if that was the standard, the arbitrator was not rational in coming to the conclusion that an offense did probably occur. He didn't identify which underlying theft offense was supporting theft in office. He didn't identify the elements. He didn't identify whether the additional elements required for theft in office were met, and didn't identify the state of mind necessary. He arbitrarily used an intent to be paid standard, which might have been his attempt to state the mental state, but then he didn't even apply that consistently. In the same paragraph, he says, Cologne intended to be paid, and then at the end of the paragraph, on the second to last page, he says, well, he expected to be paid. That's not the same thing. Intent to be paid might be a mental state, assuming it was even the right standard. Expected to be paid is not, it's a belief, it's not an intention, it's not knowledge, it's not a purpose. So there was a lack of connection throughout the entire final 3 pages of this opinion. And we think that the trial court correctly saw that and realized that it bore no relation to the collective bargaining agreement. It just, the dots did not connect.
Let me ask you a question.
Yes.
The collective bargaining agreement gives 4 reasons for taking sick leave. 4 reasons, right?
Mm-hmm.
That are approved. There's nothing really but the 4, isn't that correct?
Correct.
Okay, and then, but under the arbitrator's agreement, under the discharge, it says he shows the abuse of sick leave on April 9th and 13th when he fraudulently reported verbally and in writing that he was sick when he was not. He missed an airplane flight home, attended a funeral, which if true wasn't sick time, wasn't the 4, one of the 4 qualified sick time things. He also says that he attended a track fundraiser and he would always readily use sick time to attend his son's track career events. Right. None of those things are of the 4 uses for sick leave, though.
But you're questioning his findings of fact, and the trial court didn't question that. If you read on, you'll find that he didn't base his decision on what you just said. He went on and said the discipline, even if that happened, was not appropriate. So what you're saying is absolutely true.
There was no discipline.
Well, he's saying that that wasn't the basis to discharge. So he went through all of that exercise, Your Honor, and he looked at the sick leave provision, and he made findings that maybe there was one actual violation, maybe one instance of misconduct, which I believe was on April 13th. Then he said, under the second prong of the just cause standard, even if that misconduct occurred, assuming it occurred, the discipline of discharge was the wrong level. And in fact, he said, at most, Mr. Cologne should have been suspended for 1 day. It was after that part of the opinion, when he moved into pages 62 to 64, that he started afresh on an entirely new line of reasoning under this contract theory of bargain for consideration. So Your Honor, you're absolutely correct when you look at the terms of the CDA, but the arbitrator threw all that away when he reached his ultimate conclusion. That's the part that doesn't draw its essence from the agreement, and the parties didn't bargain for that.
Well, to that point, what did the parties, and I asked this question of the appellant, what did the parties submit to the arbitrator? What are the issues that the parties submitted?
It's very clearly stated in the trial court's journal entry. It's not numbered, but it is on page 2 of the, well, it's the second page, I believe. It says, the issues for arbitration were clearly defined, and you asked this earlier. What were the precise issues? I don't believe that appellant's counsel answered the question. Was the grievance allowed under the CDA? If so, quote, was there just cause for the termination of the employment of the grievant Cologne? Was there just cause? Not was he constructively discharged. There may have been correspondence before the parties agreed on those discrete issues, but at the end of the day, the city agreed to that language, and those were the issues, and that was what the arbitrator had authority to decide.
So if we get to, was the grievance allowed at the CDA? That's not.
That was yes. That was a yes. No one's arguing.
Right. Was there just cause for the termination? And you're arguing that that does not anticipate a discussion of constructive discharge.
It doesn't anticipate a discussion of it was a termination is justified because, and it's hard to articulate this because it's convoluted, because the resignation was voluntary, because it was induced by charges of misconduct that were not unfounded. It doesn't, because just cause is clearly, there's a clear test for that under Ohio law. And once the arbitrator applied that test, and he did apply it perfectly, and he concluded that there was no just cause, he had to stop there. He had no authority to go on and say, well, I have another idea about how we can find that this discharge was kosher. No. It's just like looking for the definition of disability in another collective bargaining agreement. You can't do that. And, you know, we understand that the case law says an arbitrator can select the quantum of proof necessary to find misconduct, whether it's clear and convincing evidence, preponderance of the evidence. That's fine, but that's not what happened here. It wasn't a matter of how much evidence the city had to show the misconduct. It was, when can discipline be applied at all? It was, if there's no just cause, here's another reason that you can discipline an employee. That goes clearly beyond the agreement.
One of the matters that was raised in the merit brief of the appellant was that the trial court overstepped its boundaries in kind of fact-finding, finding facts that were contrary to those determinations made by the arbitrator. And I have to say that in reading the trial court's entry, it really did sound like there was some of that going on. How do you respond to that?
Well, in two parts, Your Honor. First, I addressed the specific, you have to look at the specific things that they think were substituting its judgment. And I addressed each and every one of them. And all of them were simply cases of the court trying to take up, I believe, a 12-page factual recitation. I think it starts on page 51, goes to 62 or something like that, and boil it down. It was just paraphrasing and giving a summary of the facts. The second response I would have for you is that none of that informed the trial court's ultimate decision, because the trial court agreed with how the law was applied to those facts in the first part of the arbitrator's decision before the crazy part, before the page 62 to 64 part. The trial court did not question how those facts informed the arbitrator, and that was not the basis for what the trial court did at all. It was simply setting the stage to provide in a written opinion what the arbitrator found.
And now you are on the time.
I just do a very quick closing. I would just like to say,
30 seconds.
Okay, that Mr. Colon was an exemplary employee, 16 years, unblemished record, a veteran, honorably discharged. He had never received a negative performance review, and he wasn't even given progressive discipline. He was ambushed at a hearing, and in all fairness, the wrong that was done to him should be righted. Thank you.
Excuse my hyperbole, Your Honors, but my head is about to explode if I hear them say that constructive discharge was not an issue before the arbitrator. If you look at his grievance, if you look at the November 12th letter, if you look at Mr. Stumpfhauser's letter, I would venture to say that the term constructive discharge was mentioned 20, maybe 30 times. For them to say otherwise is disingenuous yet again. Having said this, if they're saying that all that the arbitrator was to do was a just cause for determination, that would be impossible. He quit. There is no determining. It's whether or not the quit was good. Was the resignation good? Whether or not the city had just cause to terminate is a secondary issue if, in fact, Mr. Colon gets let back into the door. Again, as I stated before, he must be let back into the door. The resignation must be thrown out first. So in order to do that, you have to have a constructive discharge analysis. For them to say otherwise is baffling. That is where the probable cause determination comes in. We're not using just cause standards. What Kinney says that the arbitrator was to do was to determine whether or not the charges of theft in office were founded or meritorious. That's all he has to do. Whether or not he lists the elements, which we did in our post-hearing brief, so he was aware of the elements, whether he lists them, whether he puts case law citing whether theft in office occurred, doesn't matter. Doesn't matter at all. And if you look at this and step back and look at the law, it plainly says that legal or factual errors must be accepted. So even if the arbitrator does everything wrong that they said that he did, it doesn't matter. We have to accept that. The trial court is going to only look at a very 10,000-foot macro view as to whether or not he exceeded his powers or the decision was somehow imperfect in some other matters. This is a very, very strict standard. Moving on, they mentioned several times Colon was terminated. Colon wasn't terminated. He quit. He quit because, quote, he was scared shitless. He was scared shitless of losing his job, of losing his RN license, and going to jail. He did this under the advisement of his union, union's counsel, and presumably his family and other counsel. He had 6 days to decide this. He decided only after a couple that he was going to quit. It was only 2 months later that he decided that he was going to back out of that contract.
And pardon me, but
yes,
presuming he hadn't have done that, and that the city let him go, and he decided to grieve the process,
yes,
and he went through the whole grievance process and got to the end, and as it turned out, after going through the entire process, they didn't find him.
They didn't.
I found in his favor at the end of the grievance process. There would be no just cause then, because he went through the whole process. That wouldn't stop the state of Ohio from prosecuting him for theft in office, though.
Absolutely.
There's two separate parties here who are potentially, use the word, after Mr. Colon. there's two different parties can go there.
Yes.
One of them is the union and the firefighters in the city of Lorain, and the other would be the state of Ohio.
Correct.
Which is a different standard.
Correct.
Okay.
Yeah, I mean, that's why this is not just a just cause issue. It is also a criminal issue, because if Colon had not resigned, Fowler could have used his discretion and forwarded the charges onto the authorities, which on its face shows a theft in office. He double dipped. I mean, this is as plain as day. That's why there's no major discussion, because it's as plain as the nose on our faces. Also, if you look at the transcripts, the union said at the time, well, we knew we didn't have much to do. You know, if those emails were true and correct, we're kind of screwed. That's why they decided to resign. Again, Mr. Colon brought up the idea of resignation. It was 100%, he was, quote, the 100% propelling force behind resignation. We didn't bring it up. Mr. Colon took a timeout during the disciplinary hearing with his counsel and his union and said, hey, how are we going to save my butt here? How am I not going to lose everything? I know, I'll quit. And let's see if they'll allow me to quit. And the city did allow him to quit. And then when he had an apprehension about what he did 2 months later, he tried to go back on the deal. And that's what this is about. He said that I was constructively discharged. Because if he wasn't constructively discharged, again, he doesn't get back into the door. He's still just a guy who quit. And as long as he's a guy who quits, he has no CBA rights. He has no grievance rights. And that's what they're trying to fight back, is to get back into the door so that they can get under the protection of the CBA. But when he quit on May 11th, under his own volition, with the advice of counsel and the advice of union, he gave up those rights. And now he's trying to get back into the door. And we urge this court strongly to not allow him.
Thank you. We will take the case under 5-6, send you a copy of the opinion that is issued in email. Find it on the court's website as well. Thank you and have a
Thank you very much.
Thank you, Your Honor.